Hello, we are back with another video on constitutional law. Today we shall be discussing the topic of constitutional amendments. This lecture on constitutional amendments has been divided into two parts for your convenience and for easy understanding of the topic. So, without further ado, let's get started right away. Welcome to the lecture on constitutional amendments. In this lecture, we shall be covering four subtopics. The first subtopic is we shall understand the types of constitutional amendments. Broadly speaking, there are two types of constitutional amendments. Next, we shall understand the procedure which has been described by Article 368 for the amendment of the Constitution. Later on, we shall be looking at the trajectory of the case law developed by the Supreme Court related to the topic of constitutional amendment. And finally, in this lecture, we shall trace latest developments in constitutional amendment like abrogation of the special status accorded to Jammu and Kashmir and introduction of the goods and service tax, that is the GST, by the central government. However, just for your convenience, I am trying to keep these videos below 15 minutes. Therefore, we shall discuss the latest constitutional amendments including the abrogation of the special status of Jammu and Kashmir and introduction of the goods and service tax, that is the GST, along with the case law post the Keshavnanda Bharati case in part 2 of this lecture, which will be uploaded shortly. Let us start off this lecture by discussing the two different types of constitutional amendments. Broadly speaking, there are two types of constitutional amendments in India, and they are formal amendments and informal amendments. Formal amendments to the Constitution take place under Article 368, and informal amendments include judicial interpretation and the development of usages or conventions as regards various provisions of the Constitution. Let us become familiar with one of the methods of informal amendments, that is judicial interpretation. As the name suggests, in judicial interpretation, the text of the Constitution or the words used in the Constitution remain the same. However, the way in which it is interpreted by the judiciary or the courts undergoes a change over a period of time. This method of constitutional amendment is very popular in countries which have a very rigid constitution like the United States of America. And this method of informal amendments, that is judicial interpretation, offers a huge scope for judicial creativity. Now let us try and understand the concept of constitutional amendments through conventions. Now, what is the meaning of the word convention? In this context, that is, in the context of constitutional amendments, the word convention means usage or unwritten rules. Therefore, in the case of conventions, constitutional amendments can take place in three situations. The first one is when a particular power exists on paper only. For example, in the UK, when the Parliament passes a particular law, it becomes law of the land only when it receives royal assent, that is, approval of the King or Queen of England. However, over a period of time, it has become a convention for the King or the Queen to automatically assent to any of the laws which are passed by the Parliament. Therefore, the royal prerogative, as it is called, has lapsed due to lack of usage. Next, constitutional amendments by conventions can take place during delegation of powers. For example, a particular function may be delegated by the Parliament to the executive or even a non-government agency or a government corporation. In this case, the implementation of any constitutional provision takes place at the hands of the executive. This is another example of constitutional amendment by the development of conventions. And finally, it must be remembered that conventions are not enforceable as such because it is simply usage. There is nothing in black and white to back up a certain convention. However, conventions can be binding. Now let us start with the subtopic of formal amendments. In the Indian Constitution, the method for amending the Constitution has been described in detail in Article 368. In the context of Indian Constitution, formal constitutional amendments can be broadly divided into three categories. The first category is amendment of the provisions of a temporary nature. Next, number two, it includes the amendment of stable provisions of the Constitution. And finally, number three, Article 368 describes the procedure for amendment of entrenched provisions. So what are entrenched provisions? Entrenched provisions are those provisions of the Constitution, as we shall see later, which are related to federalism or federal structure of the Union of India. Now let us try and understand the procedure for amendment of temporary provisions of the Constitution. Simply speaking, the method which is used for passing any ordinary legislative bill in both the houses of the Parliament is used for amending temporary provisions of the Constitution. In the context of constitutional amendments, amendment of temporary provision is not even a constitutional amendment, so to speak, because compliance with the proviso to Article 368 is not required. Now, you might ask me, what are some of the examples of provisions of a temporary nature? So some examples can be, number one, citizenship. The issue of being a citizen of India was a provision of a temporary nature in the Constitution, which was enacted and adopted in 1949. Number two, the pay scale of certain government employees. And number three, the language of instruction in schools and colleges. These were some examples of the provisions of temporary nature which can and have been amended by simple legislative process. Now, there are certain provisions of the Constitution which are neither temporary and nor are they entrenched provisions. So, how do we go about amending such provisions? The procedure for amending such provisions which are neither temporary and nor entrenched is described in Article 368. Such provisions may be amended by passing a bill with majority of the total membership and not less than 2/3 of the members present and voting. This is known as the rule of special majority. However, you must remember one important point. The procedure described in the proviso to Article 368 need not be followed while amending such provisions. Such provisions may be amended only by passing the required or the necessary bill by the rule of special majority. Let us try and become familiar with the method for amendment of entrenched provisions of the Constitution. Like we saw previously, entrenched provisions are those provisions of the Constitution which are related to the federal character or federalism existing within the Union of India. So what is the procedure for amendment of such provisions? The procedure consists of two parts. Number one, the concerned constitutional amendment must be passed in both houses of the Parliament by the rule of special majority. Special majority means half of the total strength of the House and not less than 2/3 of the members present and voting. And apart from that, amendment of entrenched provisions of the Constitution requires ratification by 1/2 of the state legislatures. Only then can a constitutional amendment bill which seeks to amend entrenched provisions can be produced before the President for obtaining his assent. This procedure has been described in the proviso to Article 368 and compliance with this procedure is compulsory for the Parliament. Now it is time to read Article 368 itself. The wording of Article 368 has undergone a huge change since the Constitution was enacted in 1949. On your right, I have reproduced one of the original pages of the Constitution. You can read Article 368 as it was enacted in 1949 on your right. So, it might be a good idea to press the pause button and read the original text of the Constitution. And now, after reading Article 368 as it was enacted in 1949, it is time to read the modern version of Article 368. In the next two slides, that is this slide and the one after this, you can read the modern version of Article 368. Please try to note the changes that have taken place in Article 368 since it was enacted in 1949. If you are a good student and if you have good powers of observation, you must have observed that Article 368 as it was enacted in 1949 did not contain subclauses number 3, 4 and 5. Subclauses number 3, 4 and 5 of Article 368 have been added subsequently, and in the next subtopic we shall be covering the journey from 1949 to 2024 and all the changes which have been made to Article 368 and the interpretation given by the Supreme Court to all of these changes. Before discussing specific cases, let us get a broad overview of the case law developed by the Supreme Court related to the topic of constitutional amendments. Therefore, the first case that we shall be discussing is Shankari Prasad. Broadly speaking, in this case, it was held that there is no limit whatsoever on the amending power of the Parliament to amend the Constitution. The next case which we shall be looking at is the case of Sajjan Singh and the state of Rajasthan. In this case too, it was held that there is no limit whatsoever on the amending power of the Parliament to amend the Constitution under Article 368. However, this case is important because there were two dissenting judgments which would become much more important in the later cases. The next case which came up before the Honorable Apex Court was the case of Golaknath. This case marked a turning point in the history of case law related to constitutional amendments. In this case, Chief Justice Subba Rao, who was a great champion of fundamental rights, held that the fundamental rights could not be amended under any circumstances. This was a great departure from the previous case law in which it was held that there was no limit at all on the amendment of fundamental rights by the Parliament. Therefore, this is a very important case. Next, we shall be discussing one of the most important cases in the history of Supreme Court of India, and that is the case of Keshavnanda Bharati. In this case, there was a reversal of the decision rendered by the Apex Court in Golaknath. This case saw the birth of the basic structure doctrine which still persists today. Broadly speaking, in this case, it was held that there was no limit on the amending power of the Parliament. However, the Constitution could not be amended in such a way so as to destroy the basic structure of the Constitution. Now, what is the basic structure of the Constitution? What are the characteristics which can be considered to be the basic structure? We shall look at all those questions when we discuss this case of Keshavnanda Bharati. Naturally, the Parliament was not happy by the curtailment of its power due to the ruling of the Supreme Court in the Keshavnanda case. Therefore, there was a struggle between the Supreme Court and the Parliament, and each sought to assert its own supremacy. In the following cases of Indira Nehru Gandhi and Minerva Mills, we shall look at this struggle and we shall also understand who emerged on the top. These cases are important because to an extent they define the current position of law related to constitutional amendments. Finally, in our journey of tracing the trajectory of cases decided by the Honorable Supreme Court, we shall be discussing the case known as Quixota Holohan and Zakilu. This was a case related to the 52nd Constitutional Amendment. 52nd Constitutional Amendment introduced an anti-defection law whereby members of a party were disqualified from membership of a legislature if they defected to another political party. This was one of the rare constitutional amendments which was actually applauded and appreciated by the Honorable Supreme Court, and therefore it is necessary that we must discuss it. Let us start with the case of Shankari Prasad. Shankari Prasad was one of the first case related to constitutional amendment which came up before the Honorable Supreme Court in the year 1951. You must know that in the Constitution as enacted, that is, a Constitution which came into force in 1949, the right to property was one of the fundamental rights. However, the socialist government of Pandit Nehru wanted to abrogate or curtail this right to property. Therefore, the first constitutional amendment curtailed to some extent the right to property under Article 31 of the Constitution as enacted. Therefore, this amendment was challenged before the Honorable Supreme Court. Now let us try to understand the argument of the petitioner. What was the petitioner alleging or contending? Very simply, Article 13, subclause 2 prohibits the legislature, that is the parliament, from passing any law which curtails or abrogates fundamental rights in any manner. Therefore, on behalf of the petitioner, it was argued that the word law contained in Article 13, subclause 2 also included constitutional amendments under Article 368, and therefore the Parliament was not competent to make any constitutional amendment which abrogates or curtails any of the fundamental rights. Now, what was the decision of the Supreme Court? Did the Supreme Court accept this condition or did they throw it out? Let us find out in the next slide. Let us try and come to grips with the ratio of the Supreme Court in the case of Shankari Prasad. What was the decision of the court? What did the court decide? First of all, the Supreme Court applied literal interpretation of the Constitution to Article 368. Next, it was held that the word law under Article 13, subclause 2 does not include constitutional amendments made under Article 368. And quite surprisingly, it was also held that there was no limitation whatsoever on the power of the Parliament to curtail, to add to, or to totally nullify fundamental rights. Now let us start with the case of Sajjan Singh and the state of Rajasthan. Before we discuss this case in any further detail, it is important to become familiar with the 9th schedule of the Indian Constitution. Now, when any law has been placed in the 9th schedule, it becomes immune from judicial review. Now let us try and understand what that means with the help of an illustrative example. Imagine that there is an act which is known as Act number 1 of 1950. Imagine for a moment that under this act, land can be acquired by the state government for the purpose of building wells for providing water to everyone. Now imagine that your land has been acquired by the government under Act number 1 of 1950, which is an imaginary act in this example for the purpose of building wells. And suppose that you wish to challenge the order which required acquisition of your land for the purpose of building a well. Now, if Act number 1 of 1950 was placed in the 9th schedule of the Constitution, you do not have any remedy before the High Court or the Supreme Court. You cannot challenge the order made under Act number 1 of 1950 of acquisition of your land before the High Court or the Supreme Court. Why? Because Act number 1 of 1950 has been placed in the 9th schedule of the Constitution, making it immune from judicial review. Now, let us turn back to the case of Sajjan Singh. The 17th Constitutional Amendment placed certain laws related to the acquisition of property in the 9th schedule of the Constitution. We saw previously that by placing laws in the 9th schedule, they were made immune from judicial review. Therefore, in this case, there were two questions before the Honorable Supreme Court. The first question was that insofar as the 17th Amendment curtailed or abrogated the fundamental rights, did the 17th Amendment fall within the prohibition of Article 13, subclause 2? And the next question, which was before the Honorable Supreme Court, was that whether Articles 31A and 31B, while enacting those articles, was the Parliament required to follow the procedure as laid down in the proviso to Article 368. In the next slide, we shall find out about the decision of the Supreme Court. What did the Supreme Court decide? What was its decision? Quite unsurprisingly, the Supreme Court upheld its earlier decision in the Shankari Prasad case. First of all, it was held that the fundamental rights were not eternal, inviolable, and therefore they were not beyond the scope of Article 368. Next, it was held that the 17th Constitutional Amendment was aimed at implementing the agrarian reform, and any effect it might have on Articles 136, 226 and Article 32 was merely incidental. It was held that this 17th Constitutional Amendment did not alter Article 226 in any way. Any encroachment on Article 226 was merely incidental. However, that is not the end of the story. There were two powerful dissenting judgments rendered by Justice Hidayatullah and Justice Mudholkar. As we shall see later, these dissenting opinions formed the basis of later judgments of the Supreme Court. Simply speaking, the 17th Constitutional Amendment was challenged once again in the case of Golaknath. So, what was the decision of the court? Surprisingly, the Supreme Court overruled its earlier decisions which were rendered in the case of Shankari Prasad and Sajjan Singh. Further, the Supreme Court went on to hold that the fundamental rights occupy a transcendental position in the constitutional hierarchy, and no power, none at all, not even the Parliament, had the power or the prerogative to amend fundamental rights. Simply speaking, fundamental rights were unassailable or inviolable. Golaknath was a landmark decision in the history of the Supreme Court of India. Therefore, it is extremely important for us to understand the reasoning developed by the Supreme Court while reaching this decision. So what was the reasoning developed by Chief Justice Subba Rao? It was something like this. The marginal note of Article 368 as it existed during the Golaknath case simply read, "Procedure to amend the Constitution." It did not speak at all about the power of the Parliament as such to amend the Constitution. Therefore, Chief Justice Subba Rao was of the opinion that the power to amend the Constitution is not found in Article 368. Instead, he held that the power to amend the Constitution could be found in Article 248, which describes the residuary powers of the Parliament. Now, we have discussed the residuary powers of the Parliament in our lecture on center-state relationship. So, if you are not able to recall what is the residuary power of the Parliament, simply pause this video, go back to my previous video which describes in great detail the residuary powers of the Parliament under Article 248. Therefore, moving on, since constitutional amendment was made according to the residuary power found in Article 248, Chief Justice Subba Rao reasoned that the constitutional amendment was also a law in terms of Article 13, subclause 2, and therefore it also fell within the prohibition of Article 13, subclause 2, that is, no law, including constitutional amendments, could be made which abrogated, took away, or curtailed fundamental rights in any manner. I hope that the reasoning given by the Supreme Court in the case of Golaknath is clear to you. Let us discuss a few more aspects of the important Golaknath judgment. So, it was held that the Parliament could not amend fundamental rights in any manner whatsoever. So what was the method suggested by the Supreme Court for amendment of fundamental rights? The Supreme Court suggested formation of constituent committees or constituent assemblies for amendment of fundamental rights if at all such a need was felt. However, the Supreme Court also held that the scope and the ambit of many fundamental rights had been greatly modified since enactment of the Constitution in 1949. Such amendments were in favor of the agrarian reform which was being implemented all over the country, and most of the people of India had accepted these modifications to fundamental rights. Therefore, it was decided that there would be no retrospective overruling of the amendments of fundamental rights which had already taken place. If there was such a prospective overruling, there would have been chaos all over the country. However, the Supreme Court made it extremely clear that no amendment whatsoever to fundamental rights shall be permitted after passing of the decision in this case, that is the Golaknath case. Naturally, the Parliament was not happy with the decision of the Supreme Court in the Golaknath case. Essentially, the Supreme Court had taken away the power of the Parliament to amend fundamental rights. Therefore, the Parliament sought to reverse this decision in an indirect manner by introduction of the 24th Constitutional Amendments. 24th Constitutional Amendments made several changes to Article 13 as well as Article 368. Some of those changes were as follows. Number 1, it was clarified that Article 13 shall not apply to constitutional amendments under Article 368. Number 2, as a matter of ample precaution, it was clarified that in Article 368 that Article 13 shall not be applicable to any of the amendments implemented under Article 368. Number 3, the marginal note of Article 368 was changed. Like we saw previously in the Constitution as enacted in 1949, the marginal note to Article 368 was procedure for amendment of the Constitution. Now it was changed to power of the Parliament to amend the Constitution and procedure therefore. Therefore, it was clarified that the power of the Parliament to amend the Constitution emanated or originated from Article 368 itself. And finally, number 4, a non-obstante clause was added to Article 368. We shall discuss the impact of this 24th Amendment when we discuss the all-important and the famous case of Keshavnanda Bharati in the next few slides. The Parliament also enacted the 25th Constitutional Amendment to try and get over the decision of the Supreme Court in the Golaknath case. So what was the 25th Constitutional Amendment? In essence, Article 19(1)(f) was delinked from Article 31, subclause 2. Next, Article 31C was inserted into the Constitution. According to Article 31C, any law which is implemented or enacted to give effect to the objectives mentioned in Article 39 subclause B and Article 39 subclause C was made immune from judicial review. Further, any declaration by the Parliament that a particular law was enacted to give effect to objectives mentioned in Article 39B and Article 39C was made immune from judicial review. Thus, in essence, what happened is that the directive principles of state policy were made superior to fundamental rights. Therefore, there was a reversal in the position of DPSPs and fundamental rights. Previously, it was held by the Supreme Court that fundamental rights were superior to the directive principles. Now, the position was reversed. Directive principles became superior to fundamental rights. Finally, it's time to discuss arguably the most famous case ever decided by the Supreme Court of India, and that is the case of Keshavnanda Bharati and the Union of India. In this case, the 24th and the 25th Constitutional Amendment were challenged before the Honorable Supreme Court. Before we discuss the facts of this case and the ratio of this case, let us try and understand the significance of this case. Why was this case so important and why is it a landmark judgment? All of the 13 justices of the Supreme Court participated in this case. 11 separate judgments were rendered. The hearing took place over a period of more than 60 days. And this case was argued by one of the most famous minds in Indian legal history, that is by Nani Palkhiwala. And last but not the least, the Supreme Court rendered a judgment which went on for more than 500 pages. So this was, by the then standards, the biggest judgment rendered by the Supreme Court of India till date. Let us try to understand the ratio of the Supreme Court in the case of Keshavnanda Bharati. So first of all, the Golaknath judgment, which took away the power of the Parliament to amend fundamental rights, was overruled. It was held by the Supreme Court that the word law does not include constitutional amendments made under Article 368. Next, the Supreme Court also held that the power of the Parliament to amend the Constitution was to be found in Article 368 itself and not Article 248 as Justice Subba Rao had held in the earlier case of Golaknath. This case saw the birth of the basic structure doctrine. In the case of Keshavnanda, the Supreme Court held that there was no limit whatsoever on the power of the Parliament under Article 368 to amend any part of the Constitution, including the fundamental rights. However, Article 368 could not be used to amend the Constitution in such a way that it emasculated or destroyed the basic structure of the Constitution. So, naturally, the question arises, what is included in the basic structure of the Constitution? What are some of the features of the Indian Constitution which could be considered to be its basic structure? The Supreme Court did not give a definitive answer to this question in the case of Keshavnanda. It only gave an illustrative answer. So, let us look at some of the features which can be considered to be basic features of our Constitution. They are republican and democratic form of government. Number 2, free and fair elections. Number 3, separation of powers between the center and the state. Number 4, independence of the judiciary. Number 5, secular structure of the Constitution, and many, many more. Like I said, this is only an illustrative list, and whether or not a particular feature is a basic feature or whether or not a particular provision forms the basic structure of the Constitution has to be decided on a case-to-case basis as and when those questions come up before the Honorable Supreme Court. Next, the first part of Article 31C was upheld. However, the second part of Article 31C was struck down by the Supreme Court. According to the Supreme Court, a law could not be challenged as violative of Article 14, 19 or 21 if it was implemented to give effect to any of the objectives mentioned in Articles 39 subclause B and Article 39 subclause C. However, the court could go into the question whether or not such a law enacted by the Parliament actually did achieve the objectives mentioned in Article 39B and Article 39C. Next, it was also held that any declaration by the Parliament immunizing any law from challenge before the court was invalid. No power, including the Parliament, could immunize a law from judicial review by such a self-declaration. It was the duty of the courts to decide such questions, and such a duty had to be enforced by the courts and not by the Parliament. Before we say goodbye for the day, let us quickly recall the subtopics that we have discussed so far. We started off this lecture by discussing the two different types of constitutional amendments. Later on, we discussed the two different types of informal amendments, that is judicial interpretation and the development of conventions. Thereafter, we took a look at Article 368 and tried to appreciate the changes that have taken place in Article 368 since it was enacted in 1949. Later on, we got a brief overview of the case law which has been discussed in this lecture. And finally, in this lecture, we have discussed the case law related to the development of Article 368 till the landmark case of Keshavnanda Bharati. Thank you for watching. If the content that we have uploaded so far has helped you in any way for preparation of your exams, like this video and subscribe to our channel. Part 2 of this lecture will be uploaded very shortly. Till then, Jai Hind, Jai Samvidhan.